much for your time and being on here today. Uh, the reason why we are doing this, to be honest with you, is I've had a handful of agents and the partners that work with Landmark have been requesting heavily to learn a little bit more about short sales, and obviously there are ever-changing things that happen in our market, and we're seeing a lot more of these plan out. I think, last 2 or 3 months, we've closed probably close to 10 short sale escrows. And so, unfortunately, they're coming, and we want to make sure that you're fully aware but also educated. I do know that some of my agents don't even know how to do it, and they outsource some of these transactions. But just want to keep you in the loop of what we're seeing. Of course, we deal with volume. We see a lot of escrows come in, no matter what type of situation. But today, I wanted to introduce myself. My team is not on the call today because we actually do adopt a family around this time of the year, and my team is helping put all those presents together for the unfortunate families right now that are just in need. So they're taking over, and I'm going to head over that way. But my name is Michael Crabio. I'm one of the sales representatives over here at Landmark. And so if you're working with somebody already, please continue to work with them. If you haven't worked with Landmark or myself, please feel free to reach out to me. I have my contact information in the chat feature. One thing I want to just promote real quick is every week we do a weekly webinar called Make Your Mark. The whole idea is we want you to come make your mark here with Landmark Title. We just like to present. Different opportunities, marketing strategies. I think Stacy Gross is on this call. She was on this call, but she's been one of our speakers. There she is. Yeah, so what we try to do is we just try to provide as much value to anyone in the real estate industry as possible. Today, I went over how to do video editing, because that's been a very high demand um, you know value, I guess I would say. Agents really want to learn how to do it. And so I'll be doing these in person as well. But just something out there that, if you don't have time to go to a class, you could jump on this call. It's every Wednesday at 10 a.m. And actually, this call right here was supposed to be for the Make Your Mark, but I know Patrick's a busy guy, and we just wanted to make this happen. So Patrick, thank you so much for being here. And Patrick's a great resource for anyone that is in need of an attorney, or I mean, just like today, just to get some valuable insights on this topic today. So thank you, Patrick. I appreciate your time today.
Yeah, my pleasure. Thanks so much, Michael, and thanks so much for everybody being on today. You want me to kick it off?
Yeah,
You
do your
ready?
thing, man. I know someone asked, will you be recording? We are recording this, so we'll make sure anyone that signed up will get the recording as well. And then let's learn. Let's learn a little bit.
For sure. Yeah, so the recording is available. I'm going to talk about some short sales, some foreclosures, what to do with an underwater property. And like Michael said, we're starting to see these a little bit more. We'll get into kind of what that really means and what you need to be on the lookout for. So, for anybody who doesn't know me, my name is Patrick McQueen. I am a real estate attorney here in Arizona. I own Medalist Legal, and all we do is real estate stuff. So we are keenly aware of what's going on in the real estate industry. And I was around back in the old foreclosure and short sale days of 15, 20 years ago. So very, very familiar with how this works. And we are seeing a little bit of an uptick. It's not major. It wasn't like it was in 2008, 2009, that sort of stuff. But we're seeing a little bit of uptick, and we're getting questions and we're getting calls about, hey, what does it look like if I need to do a short sale? Before I get into the short sale stuff, I always give a little bit of an additional update on some of the things that are crossing my desk right now, some of the things that are hot topics that you may see as agents out there. Okay. First hot topic number one deals with what we've been dealing with for the last quarter, which are claims pertaining to all of the rains that we had 2, 3 months ago. So we're still getting a number of rain and water intrusion related issues. So I want you to be aware of that. The first thing that rains bring out are disclosure failures. So buyer comes in, they buy a new house, and once all of this rain comes out, they realize, oh my gosh, the seller didn't disclose that there was a roofing issue. They didn't disclose that there was a grading issue and all of this stuff would flood my backyard. Those types of things. So rains are always a good reminder to make sure your clients or you're encouraging your clients to disclose everything that they know about a property. The rains and the monsoons and whatever else we had, the hurricane, whatever that came through, they also bring about water diversion claims. So we have a statute here in the state that says if you are diverting water from your property onto somebody else's property, and that diversion can happen by you putting up mounds in your front yard, mounds in your backyard, blocking weep holes. We see that one a lot. So that if you have a weep hole from property behind you and there's a weep hole between your two properties and you're blocking your weep hole so that water doesn't come onto your property, it backs up onto somebody else's property. And guess what? Their pool may be inundated with water, those types of things. That is a statutory violation here in the state of Arizona. It is ARS 48-3613. That can give rise to claims for negligence. That can give rise to attorney's fees awards if you're the prevailing party there. So if you see anybody diverting water, moving mounds, those types of things, big no. And it's also a misdemeanor, by the way. So it's a very serious type of situation that you can get into when you're diverting water. Third thing we've seen because of all of those rains, because of all of that water, are claims for the failure by HOAs to maintain common areas. So what we saw were situations where maybe somebody backed up to a preserve, maybe somebody backed up to HOA common areas, whatever it may be. The HOA wasn't properly maintaining that area. They allowed the shrubbery to get overgrown, etc. And then somebody's property got flooded because of that failure to maintain. Guess what? Now you have a claim against the HOA. So that one was a newer one for us this year. I never really saw that, but it's happened 3 or 4 times. And then, of course, we get into these warranty claims like roof warranty, paint warranty, all sorts of stuff. And finally, with the water diversion stuff, if you have a buyer or seller or a client or a friend or whoever it is, and they try to make a claim with their insurance company saying, hey, look, this flood, this issue happened and my house got ruined, whatever. Insurance denials, insurance claims they get denied usually, 8 times out of 10. And if it's an improper insurance denial, let's say that the insurance policy actually required the insurer to pay to compensate for these issues, your client or your friend or whoever it is usually going to be entitled to 3 times the amount of damages for that wrongful denial. So that's a big no-no on insurance companies. And so if somebody's running into one of those types of claims, types of issues, then they need to speak with somebody about that. Second big issue that has crossed my desk in 2025 are all of the new HOA laws. So at the beginning, in January of 2025, we had a ton of new HOA laws that came out. They dealt with how to get rid of board members. There's an easier way to get rid of board members now. It dealt with parking on public roadways within an HOA. And some of you on the call and some of you listening to this recording may have received something from your HOA saying, we need to have a vote on this. If there was no vote or it was a no vote, guess what? HOAs can no longer govern parking on public roadways, even if the HOA documents allow it. So that was a big issue that we dealt with. Agendas now need to be provided. If something is not provided, if there's an agenda item that gets discussed at an HOA board meeting or a member meeting that was not on the agenda, guess what? You now have a basis to get rid of any official action that happened during that. So we're seeing a lot of pushback on HOAs and condo associations. A couple other ones I want to bring up. Condo improvements. Even if you live in a condo and your condo documents say, hey, you can't have hardwood flooring on 2nd and 3rd floor levels. You can't have anything but carpeting, right? A lot of condo documents still say that. Those are now unenforceable. So for the longest time, people were scared to do anything to the interior of their condo units because the condo association documents refused or did not allow them to do that. Well, guess what? Now, no matter what those documents say, so long as you're not creating extra noise, so long as you're not creating a structural issue, guess what? You can put those in. So we've seen a lot of HOA related stuff that has changed, and there's a big pushback on HOAs. We also had some new laws that came out about a month and a half ago dealing with HOAs. I'm gonna tell you these ones really quickly. I'm sorry, SB 1039. If you need a printout of these, if you need a memo on these, I can get them to you. I can get them to Michael, whoever. But now an association must retain an unedited recording of any open meeting within an HOA. They have to keep those for 6 months. So now you have the ability to go in and get the unedited recording of any of those meetings. Board has to produce those. They have to provide unedited recordings. The definition, this is the second one, SB 1378. This one came out at the end of September as well. Again, somewhat of a big change for HOA stuff. Political signs, political flags, right? There's statutes, there's HOA documents that kind of clash sometimes. Well, now homeowners can actually put in their yards, even if the HOA documents prohibit it, you can put a yard sign up that contests or addresses an HOA issue. So if you don't like the fact that the HOA is trying to enforce something against you, if you don't like the fact that they're trying a new ballot measure or something like that, guess what? You can actually put up a political sign or a political flag supporting your position. So now HOAs can no longer prohibit that. So all of these, again, I think are pushbacks on HOA's authority, HOA power, condo association power. We also had some case law that also pushes back on HOA. So I just want people to know, we're a resource for a lot of the HOA stuff has just been huge, huge, huge stuff this year. So if anybody wants a checklist of those items, anybody wants a explanation, further explanation, I kind of touched those. But those two issues, again, the water issues, the rain issues, those types of things, big issue the last quarter. The HOA stuff has been an issue the last year, frankly, even before that. But now we have some legislation saying HOAs, you don't have the authority, you don't have the power that you previously did. So let's chill this out a little bit. So on to today's topic. And by the way, we're a fairly small group here. If you want to take yourself off of mute, if you want to ask me a question about any topic, this is your opportunity. It's for some free legal advice. I mean, you're getting what you pay for, but free legal advice here. If you need anything on any of these topics, let's talk about distressed properties, foreclosures, short sales, deeds in lieu, all of that stuff, all of the legal issues that may come up, for a client of yours, for a seller client of yours. Frankly, this will apply on the buyer side too, to kind of help you understand why the process may be taking longer than you think it should, that sort of stuff. Okay, so first sort of thing we got to get off the plate is what is really a distressed property? What does that really mean? Well, it's a property that's underwater. Well, what does that really mean? It means that the value of the home is less than what is owed on the mortgage. So let's say somebody owes $800,000, but the property right now is only going to sell for $700,000, either because it's in a new build community, or it's because the borrower took on additional financing and now the property can't sell for what all of that financing is worth. Maybe it's it's an over borrowing situation. Maybe it's a property that has something wrong with it and now has to be disclosed, and because of that disclosure, devalues it. There's mold, there's a structural issue, etc. So the homeowners, these are situations where the homeowners cannot sell their properties for the loan amount. Okay. And so there are a number of reasons that is. Market conditions sometimes it's bought at the wrong time, whatever that may be. But there's a number of reasons that may happen. It happens in very normal markets. And so to me, when you're talking short sales, foreclosures, any of this stuff, again, probably less than 1% of situations, but it does happen and you may run into it again in any number of situations. When this occurs, when somebody, hey, I've got an underwater property, but I have to move to Alaska, I have to move to Florida. Sometimes they'll just say, hey, I have an underwater property and I don't want to keep paying the mortgage on it because it's not worth it to me to have to continue making payments on an underwater piece of property. All of these reasons, totally valid. These are reasons that we hear all the time. Hey, I'm moving. Hey, I have to downsize. Hey, whatever it is, lost my job. Any number of these things, we hear them. And so then the person's option is really, all right, well, I guess I can continue to make payments and, see if I have the money to do that. Or they'll say, this doesn't really make sense anymore. I want to know what I can do. I need to sell. I don't want to be underwater. Really don't want to be a landlord. So what can I do here? And, I don't know if you guys have ever read a set of loan documents. If you want, good sleeping material, then read a set of loan documents. But we have a set of loan documents that are typical here in the state. They're typical in other states. There's not much you can do about them. But in these loan documents, the two primary loan documents that I look at, number one, the note and the deed of trust. The note is simply, I, Patrick, I, Michael, I, whoever I am, I promise to pay you $800,000 based on these terms. So there's the note and there's the deed of trust. There are actually three parties to a deed of trust: the borrower, the trustee, who actually holds title in trust for the beneficiary or the lender. Okay, so it's not a two-party document. It's actually a three-party document. Borrower, trustee. Trustee can be me. There's a number of people that can be considered trustees. Title companies can be trustees, that sort of thing. So borrower, trustee, lender, or beneficiary. And under these loan documents, under the note, under the deed of trust, those are the two primary documents, as I mentioned. The lenders can do, or they claim to be able to do, a whole host of awful things to you, right? They can sue you for a deficiency. They can foreclose on you. They can do all, they can get judgments, and they can do all these scary things. They can do both of these things. They can do all of these things. And so the remedies for a lender are, the remedies section under these documents are incredibly lengthy, incredibly confusing. But really, a lot of this stuff is a head fake, right? So the lenders reserve all of these rights under the note, under the deed of trust. But in reality, there's only really a couple of things that the lender can do. And that's because of the way our case law works. That's because of the way our statutes work. Okay. And so I'll get into this. So the first option that a lender can do, and what most lenders do, if you're not doing a short sale, so what most lenders will do is what's called a trustee sale. So remember, there's three parties to that document. There's three parties to that deed of trust. And what they're basically doing is saying, hey, trustee, our borrower has stopped making the payments. I want you to conduct a trustee sale to get me this property back, and conduct this trustee sale. So the trustee sale is based on the power of sale in the loan documents, or in that deed of trust. Okay. It is a non-judicial process. It is not a lawsuit. So it is basically some paper pushing by that trustee to initiate this process. The typical trustee sale works like this. Borrowers will go about 3 to 4 months behind. They'll stop making their payments for whatever reason. Maybe it's strategic. Maybe they wanted to make the payments, but they just couldn't. Whatever it is, borrower stops making the payments. Usually the borrower goes about 3 to 4 months behind. The lender says, okay, this guy's not making his payments. We need to do something here. And the lender in that situation, they'll send out a bunch of notices, a notice of default, notice of transferring the trustee's name, all sorts of stuff. Again, highly technical, required by statute. They'll also, this is really the key for me, is they will post and record what's called a notice of trustee sale. The notice of trustee sale will have a date that's at least 90 days in the future. That will be the date of the trustee sale. That'll be the date of, when somebody else takes ownership of the property. So if you think about it from a strategic standpoint, if somebody's saying, hey, how long can I stay in my house without making a payment? This is a common question, believe it or not. How long can I stay in my house without making a payment? Again, 3 to 4 months behind, then at least 90 days based on that notice of trustee sale. There has to be that 90-day period. Okay, no matter what, the 90-day, the 3 to 4 months behind, sometimes it's a little bit longer, sometimes it's a little bit less, but on average, 3 to 4 months behind, and then automatically borrower gets that 90-day period on that trustee sale date. That'll be the date that somebody gets what's called a trustee's deed. That'll be the date that new person gets that deed and owns the property. These sales are conducted on the courthouse steps, in law offices, title companies, that sort of stuff. It's easy to buy. If you represent a buyer at one of these, they need a check for a certified funds for $10,000, and they can get it if they're the winning bidder. Okay, this is important for me in terms of legal remedies. But prior to the trustee sale, the borrower can do what's called a reinstatement. The borrower has the ability all the way up until 24 hours before that trustee sale to reinstate their loan, meaning they pay back all of what is owed as of that date, plus trustees' fees, plus attorney's fees, late fees, those types of things. It's not a payment in full of the loan. It's whatever is owed, with whatever those 6 to 8 months worth of payments, plus some additional fees. They can fully reinstate the loan. The trustee sale goes away. Okay. They have to do that. They must do that at least 24 hours prior to the trustee sale actually happening. If you fail to pay that off, the trustee sale will happen. Somebody gets a trustee's deed, which is a very strong deed under Arizona law, and the borrower has nothing else they can do. So we can't, if a borrower is dealing with a trustee sale date, we got to take that date very, very seriously. If they miss the opportunity to reinstate and the trustee sale happens, guess what? The likelihood of being able to get that property back is very slim to none. I mean, you may have a claim for a wrongful trustee sale or something like that. You didn't get notice, you didn't whatever, or you actually reinstated, but it's incredibly rare. So if you are going to contest the ability of the lender to actually do this trustee sale, you have to do it before the trustee sale happens. If you're going to reinstate, that is a right you have up until about 24 hours before that. Okay. Now, again, afterwards, in some states, borrowers can what's called redeem their loan, meaning get it out of foreclosure after the trustee sale happens. We don't have that ability here with the trustee sale. You have the right to reinstate. You don't have the right to redeem. Okay, so we want to make sure that people are clear on that. So if you're going to pay back this this amount, get it out of the trustee sale, you have to do it prior to that trustee sale. You can reinstate, you can't redeem. So the next question I usually get is, okay, I'm okay with this idea of going through a trustee sale. We'll talk about all the other options, because I think short sales are usually going to be the borrower's best bet. But borrowers always ask me, hey, if my property goes to a trustee sale and I no longer own the property after that trustee sale, what can my lender do to me afterwards? And that question depends, well, I should say the answer to that question depends on three different sort of elements that I look for. And this is stuff that I don't really want you guys giving out as legal advice, because I think it's legal advice, but I want you to know it, just so in the back of your mind you can say, oh, okay, yeah, I got that one right, or I didn't think about that. So to qualify for anti-deficiency protection under our statutes and under our case law, the things that I look for, the things that I ask, first thing, is the home situated on less than 2.5 acres? Yeah, okay, it's in a neighborhood. It's whatever. Yeah, it's only an acre, whatever. As long as the property is situated on less than 2.5 acres, okay, we're good. We're going to go to the next question. Okay. And again, the question is, what can my lender do to me? So in that hypothetical situation where the borrower owes $800,000, but the property can only sell for $700,000, we're talking about $100,000 monetary deficiency, right? So what can a lender do? First question, is the property situated on less than 2.5 acres? Cool, it is. Is the property utilized as a single family home? Oh yeah, it's my house. Or yeah, it was a rental. I rented out to somebody. Yeah, good. You qualify for anti-deficiency protection. The third thing that we look at, the third thing that we analyze is how much of the money that is currently owed, how much of that can be traced back to or attributed to the purchase money mortgage that the borrower took out when they purchased the property. Okay. So in our situation, in our hypothetical situation, our borrower had one loan and they owe $700,000 on it. I'm sorry, they owe $800,000 on it. The property sells at the trustee sale or goes back to the lender for $700,000. They have the one loan. They never did a refi. All of it was considered purchase money. Guess what? Lender can't touch this borrower. They can't do anything at all. Okay. Now, if this was a situation where the borrower initially took out $500,000, and then at the trustee sale, by then they owed $700,000 because they did a second mortgage. They did a HELOC a year or two down the road. Guess what? the HELOC is not protected. So the lender can foreclose, they can wipe out all of the other liens, and that second mortgage lender, that HELOC lender, has the ability to pursue that borrower because, again, we're looking at purchase money mortgage. How much can be attributed to that purchase money portion? Now, somebody does a term only refi or a rate and term only refi. They initially purchased the property in 2021. They get a, well, they're not going to do a rate and term refi if they purchase in 2021. Let's say that they needed to do a rate and term refi, right? Some people are doing those, or they ultimately did one. If you're doing is refinancing for rate and term, again, you have protection. The case law actually interprets that and says you have the protection there. So rate and term, great, you still have protection. If you go out and take a second mortgage out for a HELOC after you purchase the property, even if it's 30 days after, guess what? That second mortgage is not attributable to the purchase money mortgage. Guess what? No protection there. Okay. So this becomes a bit of a strategy session that you want your clients to engage in before you even list this property, before they decide what they're going to do. So we have to look at this analysis. We have to see how many refis they did, if any. We have to see if there's a HELOC. We have to see what else is out there, what they've done with this property to ensure that they've got anti-deficiency protection. Anti-deficiency protection gives your clients and us a lot of protection if it goes into trustee sale or if it goes into a short sale, which we'll talk about in a second. Okay. So I just want you to know that this is the primary analysis that we have to do to determine what, if anything, the lender can do, whether it's on a trustee sale, after a trustee sale, or in connection with a short sale. Okay. We want to empower these borrowers, we empower these homeowners to know, hey, this is what I face, therefore I'm going to choose this option as opposed to this option. Okay. So there's a question in here. So Nancy says, what about liens? What about liens acquired to improve the property? That's a great question, Nancy. If the lien or the mortgage or the loan was acquired after somebody purchased the property, so it's a home improvement loan. Hey, we want to put in new landscaping. Hey, we want to redo the pool. Hey, we want to put on an addition, etc. Not protected. Okay. Even though you may have a tax benefit for doing that, even though that may increase the value of the property, it doesn't matter for purposes of our anti-deficiency statutes, our anti-deficiency laws here in the state of Arizona. So a lot of people goofed that up 10, 15, 20 years ago when all of this stuff was really kind of being shaken out. Liens or mortgages to fix a property, not going to be protected. Okay. So that is not considered purchase money. So Michael says, what about mortgage loans from credit unions? So credit unions they act a little differently. They can't get around our statutes. They can't get around, they cannot get around the way in which our statutes work. So a lot of times, credit union is going to say, well, we're different. We don't have investors. We have members and that sort of thing. So we're different. And therefore you need to give us a payout here. The answer is no. They can't ask you to contract around anti-deficiency protections and the protections that are afforded by our statutes. They may very well try. They may very well try. And what credit unions will do, what we've seen credit unions do in the past anyways, is they'll actually take money out of your bank account. And so the credit unions will do that. They'll say, hey, you've got, $50,000 on deposit here. And in their documents, it says something to the effect of, if you're ever, bad on a loan with us, we're just going to withdraw it from your account because we operate differently. Okay, they can actually do that. And so if you're thinking about a situation where you may need to go into a trustee sale, you may need to go into a short sale, et cetera, with a credit union, yeah, be a little more careful. They can't actually pursue you afterwards, and they really can't be taking your money out. And so in those situations, you may need to get an attorney involved to say, hey, look, he's got anti-deficiency protection. You went and took all of this money out. You weren't entitled to do that. You weren't allowed to do that. So they will try. They'll give you a head fake. A lot of lenders out there will give you a head fake. Remember, these loan documents are based on head fakes, right? They're all based on head fakes because they include all sorts of remedies. They include all sorts of scary stuff in them. But ultimately, the statutes turn around and say, no, not so fast. even in situations where it is clear that somebody has anti-deficiency protection, we still see people, we still see lenders sending in demand letters. Sometimes they'll even try to file a lawsuit. But again, they can't do that unless you let them. So we don't want to let them. We don't want to lose our anti-deficiency protection by admitting something, by saying something we shouldn't, those types of things. The other way that you can legally lose anti-deficiency protection, again, our statutes say if you have this scenario that I went through, and we can talk about specific loan scenarios because there's a couple of nuances. I do want to tell you about one, but the one way you can lose anti-deficiency protection is by committing what's called legal waste. Okay, legal waste, it's actually hard to define. So I'll give you an example. Let's say that I have a property, I've got a loan on it, and I'm gonna let the property go. I'm gonna let it go to foreclosure. And I stop paying my insurance, and there's a fire, and there's vandalism, and whatever. Well, that's considered legal waste because you still have an obligation to protect your property by properly insuring it, by taking care of it during the foreclosure process. You don't want to let the lender come in and have this argument that says, well, you committed waste. We now have a much more devalued property than we initially thought. We are coming after you. You've lost your anti-deficiency protection because of waste. It doesn't happen that much, but in some instances, when your mortgage and the monthly payment that you make is tied to insurance, you have an escrow, et cetera, and you stop making that payment, there may become a lapse in insurance. You want to make sure that that does not happen. And so that's really the only situation in which you can commit waste. Now, let me just go through this scenario because it's a little bit of a mind mind blowing kind of thing. We had a situation one time, and I'm just outlining this because I want to show you the importance of going through the analysis that we just went through. We had a situation one time, person buys a property, $500,000, all cash. Okay. They paid all cash for it, or they paid it down, or they paid it off at some point. So they've got a free and clear house. The property is now worth $1 million. They go and they take out a loan for $500,000 after after it had previously been paid for, right? So now we have a property. They take out a loan afterwards. The property was paid off. So this is no longer purchase money, right? This is no longer qualifies as purchase money because they didn't use any money when they purchased it. Property goes and the guy says, hey, I don't want to keep making this payment. I've taken this subsequent loan out on this property. It previously had no mortgage. I didn't use a mortgage to pay for it. I didn't use any financing, but now I owe whatever I owe. And in that scenario, you have to be very, very careful because in that particular scenario, the lender can do what's called a judicial foreclosure. If they do a judicial foreclosure, that means, hey, we recognize that this is not purchase money. We're coming after you for the deficiency. We're coming after you for the property and for the deficiency. If the lender doesn't catch on to that, and most don't, that person should not be doing a short sale. They need to fly under the radar, allow the property to go to trustee sale, because after a trustee sale in a single mortgage situation, so when you do a refi of a single mortgage, even if you do take out extra cash and the lender proceeds to foreclose by trustee sale, there's no deficiency. Okay. If the lender in that situation went through what's called a judicial foreclosure, that means the lender caught on that this is no longer purchase money. They're going after that deficiency. So what you want to do in those situations and why that pre-screening, whatever call you do makes the most sense is because we might not want to advertise to this lender to look into things to understand what really happened when this was purchased, what may constitute purchase money. And so in those situations, we say, let it go to trustee sale. If you do a short sale, the lender might start digging into what really happened here, and you run the risk that the lender is going to pursue that. So we've saved people, you may be able to save people a lot of heartache if you kind of just, you know what, we'll move on, find another property, short sale, it's not going to be this one. So have to be very, very careful because this stuff can get a little bit nuanced. But the basics are, again, less than 2.5 acres. Property has to be situated in less than 2.5 acres, has to be utilized as a single family home. It can be a rental, can be, your investment home up north, can be a vacation home, whatever. And then what we look at is purchase money. And then there's those slight little nuances for waste. So you got to be careful there. And for situations where somebody has a single loan and has done that a little bit of a cash out refi. So those are the sort of situations that you want to be a little bit more mindful of. Now, so that's trustee sale, and people commingle or associate the words trustee sale and foreclosure. They're technically under our statutes two different things, right? We have the trustee sale where the trustee is going through the process of selling the property. It's non-judicial, and then we also have judicial foreclosures, which is a lawsuit to foreclose. So people mix those things up. They're two completely different processes, but when somebody says foreclosure, they usually mean trustee sale. Okay, so let's say that the borrower here doesn't really want to go through the trustee sale process. They want to save maybe a little bit of credit. They want to do a short sale, and they think that that's the right thing to do. And in many circumstances, it is. Short sales are not a remedy that is outlined in that note or the deed of trust. So remember what I said. The lender has all sorts of remedies in the loan documents, but there's no reference to a short sale. And so a short sale is this private agreement that sort of overrides the note and the deed of trust. The lenders don't really advertise this. Again, it's sort of something that you have to go and say, hey, do you have a short sale department? I have a borrower here, or I am a borrower here, and I want to ask you to allow me to get released from my loan documents for this short payoff. That's really what it refers to. It's a short payoff. If the lender agrees to something like this, if the lender agrees to allow this borrower, this homeowner, to do a short sale, as an agent, I'm going to tell you I want to see two things. And I'm going to tell that borrower I want to see two things. So again, we have that call at the beginning that says, hey, yes, short sale's fine. At the end of the day, when you have a contract and you've provided whatever information that the lender wants to see, they're going to produce what's called a short sale approval letter. Okay, each lender, if there's multiple lenders, that you need to get this document for your clients, and you're going to and generally lenders know that this is what you want to see. But you need to see two things. Otherwise, short sale may not be the best idea. So we want to see the lien release, right? In the short sale approval letter, it needs to reference that the lender is releasing the mortgage lien of record of title so that the borrower can come in and get clean title. Okay, that's pretty basic. That has to happen, right? But what we really want to see, from my perspective, is deficiency waiver language in there. Okay, so in a short sale approval letter, you're going to either get one, two, three. I've seen sometimes where there's three lenders, but in most there's one or two. We want to see those two things. We want to see the lien release, and we want to see a written deficiency waiver where the lender says, hey, we as Wells Fargo or whoever it is agree to release the borrower from any future liability associated with these loan documents. We want to see that in writing. We don't want to rely on phone calls. We don't want to rely on anything else. The reason we want to see that, the reason we want to see written deficiency waiver language in a short sale approval letter, is because we know how the trustee sale statutes work. I just went through them. We go through that analysis, and afterwards, there's no likelihood of deficiency. There's no likelihood that the lender can pursue that afterwards, as long as you meet those characteristics. Our statutes say that. Our case law says that. But what we don't have are statutes or case law that say anything about a short sale. Okay, so we know how it works out on a trustee sale because that's how our statutes work. That's what our statutes say. That's what our case law says. The statutes, the case law, there's nothing pertaining to deficiency after a short sale. And so what we say in those situations is, all right, we understand that. We want you to specifically agree to waive your right to pursue any amounts from us after the short sale. And it's added protection. Now, we may have an argument that says, well, they are otherwise qualified for anti-deficiency protection, so stop giving them a hard time. You can't pursue them. But we don't really want to have to rely on that because we don't want some lender that says, well, there's a $100,000 deficiency. It's worth it to us to try to get this. Okay. So we want those two things in our short sale approval letter. After that, the lender, if they try anything, you're just going to say, here's my short sale approval letter that you signed on such and such a date. We're good, right? So there's a question here. It says, does a short sale fully protect the owner's credit, or is it still a hit on their credit if they have only one loan for the original purchase? It's still a hit. It's still going to be a hit. And the hit usually actually comes when the borrower misses their first 30, goes late 30 days, and that's the big hit usually. But there will also be a hit when the lender settles for less than what's owed. There'll be a reporting that says settled, account balance settled for less than what's owed. And I'll get in a little bit more into the credit stuff. Um, the credit stuff is so high. The way FICO scores go, it's so highly regulated, or I shouldn't say not highly regulated. But I should say it's sort of secretive, actually. Um, I don't know what if I did a short sale today, I may lose 250 points off my 800 credit score or whatever. Somebody else may lose 100 points. I don't know because those calculations are so heavily guarded. We don't know exactly what that hit's going to be. But I can tell you, if you go late on your mortgage, that's a 30-day hit. That's a big hit. That's one of the biggest hits. Once you settle for less than what is owed, that's going to be reported like that, and your credit's going to drop as well. So in terms of actual points, I don't know. There will be, sorry. I had to cough there. There will be a hit. So you're not going to be able to fully protect anybody's credit. It'll protect a little bit more under Fannie and Freddie guidelines. Borrowers who do short sales are usually going to be able to get approval to purchase another home a little bit quicker. So that's really the main benefit, is maybe a little bit less of a credit hit, the ability to qualify a little bit sooner, but still going to take a hit no matter what you do. Trustee sale, you're going to take a hit. Short sale, you're going to take a hit. This third option that I'm going to tell you about is a deed in lieu of foreclosure. These are, I don't want to say they're like urban legends, but they're tough to get. A deed in lieu of foreclosure is the legal equivalent of somebody mailing in the keys to the house to the lender, saying, here you go, take the property back. And here's a deed, by the way, from me to you of the property. You can't really do that. You have to get approval for that. So a deed in lieu of foreclosure is literally a deed to the lender saying, hey, you don't have to foreclose. You don't have to go through this process. I'm just going to give you the keys. I'm going to give you the garage door opener. The property is now yours. Lenders actually have to accept a deed in lieu of foreclosure from the borrower. You can't just go and say, hey, here's a deed, property's yours. Just as much as I can't go to Michael and say, here's my property, here's a deed. He has to accept it, right? There's the legal acceptance under our case law that says you have to accept this. Otherwise, people just go around randomly recording deeds to other people. You can't do that. So it is an immediate conveyance. A deed in lieu is an option. It's an immediate conveyance. It is not in the loan documents. It's, again, the equivalent of just mailing in the keys. And again, lenders have to approve it. If the borrower's lender says, yeah, we'll do a deed in lieu of foreclosure, we have to basically have the same language that we had in our short sale approval letter that says, okay, once we accept this deed in lieu of foreclosing on you, we're going to agree to release our mortgage lien, and we are going to agree to release you from liability. So again, it's a way of potentially getting rid of that property a little bit quicker, maybe a little quicker than a short sale, but it's not a guarantee. And so you may call the lender, the borrower may call the lender, say, can I just give you this property back? And the lender's going to go, no, we want to wring you through the coals and make you do a short sale, or we're going to foreclose, etc. So it's an option. It's not in the loan documents, but it's out there. And so you may hear about this, but they're very tough to get, particularly in situations where there's more than one loan. Because what happens is, if I give you a deed in lieu of foreclosure, the lender may say, well, there's a second mortgage out there. I don't want to take secondary to the second lender. I'm going to have to foreclose on them anyway. So forget it. We're not doing it. So only in situations where there's one loan does it really make any sense for a lender to even do a deed in lieu. So again, you're really pursuing these other options: foreclosure, the trustee sale foreclosure, or a short sale. So those, to me, are your primary three options, right? We have short sale, we have trustee sale, and we have a deed in lieu. Sometimes a borrower can get a loan modification. Sometimes they don't want it. Doesn't make much sense. They were fairly rare, I thought, back a long time ago. I think they're going to be fairly rare again. And then the other option is judicial foreclosure, which you don't want to see. A judicial foreclosure, again, is a situation where it's a court supervised foreclosure. So a lot of the same laws still apply, but it is more of a court supervised situation. Whereas the trustee sale, remember, is just the trustee doing it themselves. There's no court oversight. A judicial foreclosure involves court oversight. when you see a judicial foreclosure, it either means a lender is going after a deficiency or a lender believes that there's a problem with their loan documents. So, maybe they had a situation where the borrower has a defense to payment, like the lender made a promise that, they didn't have to pay for a certain month or whatever it is. So it's usually in those two situations. So judicial foreclosure is actually pretty rare, and we see it in situations where lender lost a loan document or they're pursuing that deficiency. So again, remedies, primary remedies: trustee sale, short sale, deed in lieu, maybe a loan modification, and sometimes that judicial foreclosure. So remember what I said at the beginning. There's all these head fakes. There's all sorts of stuff in the loan documents to say this is what we're going to do. Well, this is really what they're going to do. It's one of these three, maybe four or five options that they really have. Now, what we've seen recently is a situation that's rather unfortunate. And Michael may be able to help with something like this in putting together lists like this so that you can market to these folks. But we've seen situations where there are what's called excess proceeds. And so let's say that somebody stops making their payment. They were sending it to the wrong place. They're out of state, they're medical issues, whatever it is, and the lender forecloses on them. They do a trustee sale on them, and there's excess money. There's extra money afterwards. So, property sells, the borrower owes $400,000, but at the trustee sale, $500,000 is the winning bid. And so there's this extra $100,000. You using round numbers, they're never this round. But let's say that there's $100,000 of extra money. Well, what will happen in that situation, because the borrower had equity and they didn't know what was going on, they have this extra $100,000 that has to get deposited with Maricopa County Treasurer's Office or Assessor's Office, and then there's a fight for that money. So all of the lien holders, any HOA, the borrower themselves, they all have to respond to this lawsuit. It becomes a big mess. And so this is an opportunity for people who may have equity. And so I think Michael can probably put together a list that says, hey, these are people in trustee sale, but this is the actual value of their property or something like that to say, hey, these may be people that you want to market to because they need to know that this is actually could be a regular sale. Like they don't have to go through this process, potentially lose their house, potentially lose all of that equity, have to fight in an excess proceeds lawsuit to get some of that extra money back. So anyway, that is Michael. Do you guys do any lists like that?
We do actually. So we get something probably about once a month. To be honest with you, we don't just give it out to every single agent because I do know title companies that just, I feel bad for, people that are in this situation and just get hammered by agents. But if you are interested, we do get a list. Just reach out to myself or your business development manager, and we can put you on that list so you can get it reoccurring.
Yeah, because that's definitely a sad situation where somebody could have done a regular sale
Right,
and now they
exactly.
gotta, they're losing their house and now they have to deal with a lawsuit involving multiple parties. They don't know where that money went. They just want the money.
Right.
So yeah, so there's excess proceeds. Other couple of other issues that people need to know about. We talked about the credit. All options are going to hurt your credit. There's nothing I can do about that. Usually, we saw or we see the least impact when people do a short sale, the ability to purchase sooner with a short sale. But that first 30-day hit, if somebody's going late, that's the big one. We usually see that. The other issue that we see are HOA situations. Okay, so let's say that you have a borrower who's in a home and they have to move and they stop making their payments or they get laid off or they, whatever, they can't afford the house anymore. And they make the decision to stop paying their lender. Okay, fine. They know the hit they're going to take. They know the risks. And sometimes they stop paying their HOAs. Well, that's a big no-no. You may have anti-deficiency protection. Anti-deficiency protection refers to the lender's ability to pursue you after the trustee sale, after the short sale. The HOA isn't part of that. They will go after you and they will pursue you for that non-payment. They'll sue you. So the CC&Rs are a personal obligation, they're a property related obligation, and so the HOAs will absolutely go after somebody even if the lender says we know we can't go after this person. The HOAs absolutely will. They do. So that's one of the other issues. In terms of insurance, we talked about that one. That's a big one. You don't want to commit waste. Make sure the property is insured. Taxes, property taxes. Sometimes people will say, okay, I'm not going to pay my lender. Do I have to pay my property taxes? And the answer to that is probably not, right? So property taxes, they're not really addressed in our anti-deficiency statutes. They're not really addressed in case law pertaining to this stuff. But property taxes, there's really no harm if you don't make the property tax payments, because what will happen is the lien associated with the property tax that you owe, there's a tax lien sale. It's every February. Somebody can buy that lien and they'll start charging interest on that lien until you pay it off. Well, guess what? If you're already out of the house in that 6 to 8 month process, that tax lien holder can't foreclose on that property to foreclose on that tax lien for 3 years. Okay. So if you make the decision to not pay the taxes, there's really not a harm. There's nothing that anybody can really do, because you're going to lose the property anyway. So, to me, I wouldn't pay the property taxes then, because there's, from a legal standpoint, you don't really have to, because worst case scenario, you lose the property to a tax lien foreclosure sale, which happens 3 years down the road. You don't even own the property. So anyway, to recap, lender has less options than they think they have, right? Trustee sale, we talked about, short sale, deed in lieu, sometimes judicial foreclosure, which you can go either way. It means the lender is pursuing a deficiency, or it means the lender is concerned about a defense. There's also loan modifications, which can happen in certain circumstances. Lenders may be able to pursue a deficiency. We look at those three factors: less than 2.5 acres, utilized as a single family home, purchase money. Remember to sort of go through that analysis. Short sale are usually going to be the borrower's or the homeowner's best option for credit purposes, for qualification purposes, but you need anti-deficiency waiver language. You need lien waiver language, has to be in writing. Pay HOA obligations, pay insurance, but probably not on the property taxes. And finally, don't give any of this information to your clients. Know it in the back of your heads, because I don't want anybody out there practicing law when they shouldn't be. Nancy has a perfect question here. Nancy says, what can we do as real estate agents to help homeowners initiate a short sale? What's the right way to go about this? First step is, if you think somebody's underwater, tell them to talk to a CPA, tell them to talk to an attorney. I mentioned CPA because there's a potential tax issue here as well. I'm not going to give anybody tax advice. I'm never going to give anybody tax advice. That's way above my pay grade. But in many circumstances, if you have a property that sells for less than what is owed and that lender sort of forgives the debt, if the property is worth $500,000 and you owe $600,000, and you either do a short sale or that trustee sale, there's that $100,000 deficiency. Irrespective of whether that lender can pursue the monetary deficiency, Uncle Sam is going to say, hey, there's another issue over here. We may have what's called forgiveness of debt income, when the lender forgives debt. And so that may be picked up as income to that borrower for that particular tax year. Again, have your clients talk to a CPA about that. So that is a potential issue. So if you have a client and you think they're underwater, first tell them, talk to a real estate attorney, figure out, do you have anti-deficiency protection? Go through this analysis that we just went through, talk to a CPA to see what type of hit you may be taking from a tax perspective. I don't want people confusing those two issues, because one is, what can my lender do? That's what I can resolve, what your lender can do. I can't resolve what Uncle Sam may be able to do in this situation. That's a CPA question. So again, Nancy asked, what can you do? Well, if you think somebody's going to be underwater, or if they've already missed their first or second mortgage payment, okay, talk to these two people. Second thing is, you're going to go and get a credit. You're going to go and get a contract for this property, right? So you're going to get this property, go through the process, see what the property can get, and then you submit that to the lender and say, hey, what is the short sale process with you? What do you need this borrower to provide? What do you need to see from me to confirm that this is an accurate price, to confirm that we're getting enough? And what you'll see are lenders that are going to say, well, it's not universal, But a lot of lenders are going to say, well, we want to see some sort of hardship. We want to see that this borrower is experiencing hardship. They're moving across country. They've got a medical situation. They've lost their job. We want to know what that is so that we can sort of, figure out what we want to do here. And then we also want to see how much money they have. We want to see what's in their bank account. And so long as that borrower has anti-deficiency protection, I'm actually okay with the borrower providing that kind of information to a lender. If the borrower doesn't have anti-deficiency protection, to me, end of story, let them go through that trustee sale because this is part of that analysis. We don't want to give the lender any clue that they may not have, that they may have the right to pursue additional amounts. We don't want to give them a roadmap to where these assets are. And so that's why that conversation needs to happen. So in situations where it is clearly the borrower has anti-deficiency protection, then to me, it's like provide all the lender wants. They can't do anything with that information. If there is no anti-deficiency protection or it's limited in some way, it's like, yeah, maybe we don't want to provide so much information because if the lender decides to pursue the borrower after a short sale, the borrower after a trustee sale, et cetera, we've now provided them with where their banks are, how much they have, are they worth going after? So again, that's part of it. So to answer your question, Nancy, you tell them to seek a CPA, you tell them to talk to a real estate attorney. You then usually have to go and get a contract. The lender's going to say, we want to see a bunch of information. In most of those situations, I'm okay providing it, or I'm okay suggesting that the borrower provide it, unless there's no protection there. And then the lender's going to do whatever analysis they need to do. They're going to lose the paperwork like at least 3 times. They're going to ask for more paperwork. It's going to be a big, cluster. And eventually, the lenders will say, okay, yep, we think that the 460 you got under contract here is the correct amount. Here's a short sale approval letter. These are the things that we need to see in order to approve this short sale. And that's the short sale approval letter. And that's the key. And so have an attorney review that as well at the end of the day. So the attorney review, what we normally do is we'll say, hey, look, if we talked to you 3 months ago before you initiated this process, and you go through the short sale process, we're going to review that short sale approval letter for free. Like it's not an additional conversation. So as long as you have that pre-conversation, then there's no charge when your real estate agent brings us that short sale approval letter to review. Yes, and Stacy says document who you talk to with each time. If they're in Arizona, you can record it. In some other states, you may not be able to record it, but absolutely. Michael asked, does the borrower receive a bigger ding on their credit from a trustee sale versus a short sale? I would say yes, usually. I don't know that that's absolute though, because of the way they're so heavily guarded. I've seen people lose more on a short sale because the short sale process dragged out so long because there's a huge deficiency than on a trustee sale where they lost 150 points and it went through in the 3 to 4 months plus an additional 90 days. So it depends. I would say the bigger ding is typically in the trustee sale, but I don't want to say that's absolute because it's not. Because I've seen situations where people will do a trustee sale and they won't lose as much as I thought they were going to. And I've seen short sales where the borrower loses a lot more than I thought they would. So it's tough to say, but I would say overall, in the 85 to 90% of the cases, it's better for credit to do the short sale, and the ding is less significant for sure. Let's see. I have a buyer who wants to buy 5 acres behind them. Taxes were not paid, and there's a tax lien owner. I've done a search to find the current owner. According to the county, the owner is an LLC, and title cannot find the owner. Any advice on where to find the lien holder or current owner? Oof. We work with private investigators that can kind of do this stuff, that may be able to find the owners, and be able to communicate with them. Michael may have his own, but you're welcome to contact me after this. I'll put my contact information in the chat. I can get you with certain people. In some instances, what you do, Patricia, is you simply send a letter to either the Secretary of State or the Corporation Commission, and they can act as some form of stat agent to find them. Okay, so Stacy says seasoning with foreclosure is no longer is longer than the short sale. So yes, the foreclosure has a bigger impact. Yeah, I didn't want to say that's absolute, but that's pretty much absolute. Yeah. Who is the title company? Oh, Michael's asking, I think you're asking Michael, you're asking who the title company is? Yeah. I don't know.
Yeah, no, I was wondering if she'd respond, but it's all good if she doesn't want to chime in. So
Hopefully it's not you guys.
I know, I know.
So I'm going to put my contact information in the chat. And this is a hard line. So uh, sometimes people try to text that hard line. So it's a hard line. It's not my cell. And then I don't hear from them. What is the price range for a consultation regarding homeowners facing this situation? We charge 225. It's a 30-minute conversation. So Patricia says it's not you guys, Michael.
Yeah. Patricia, reach out to me. I put my number up in the top of the beginning of this chat. Maybe third time's the charm. We could take a crack at it and see if we could help you out. So but yeah, Patrick, thank you so much for your time today, man. Like Patrick said, save his contact information. I know he works with a few of us over here at Landmark too, so he's been a great resource to a lot of the agent partners that we have. So feel free to reach out to him whenever, and then I'm sure we'll have you back on here again with some more things that requests from agents because you're a wealth of knowledge, and we just appreciate your time today. So thank you, brother. I appreciate it.
Yeah, my pleasure. And let's book them. Let's get them going and
Yeah.
tell me the subjects. We'll plow through it. Maybe we do the HOA one in more
Okay.
detail or something like that.
For sure. And I would love your guys' feedback too. I know I'll be sending out a email to everyone that's on here on this call. Love to know some of the topics that you guys want to know about because of course you guys, are in the day to day more than us as we're, trying to talk to agents and help them with their escrows and title needs. But love to hear your feedback on it. And then we'll all be in touch soon. So thank you so much, Patrick.
You got it. See you guys.
Have a good one, guys.